There are some views that ADR is the trendy new fashion. I would like to echo the aspect that what you have in ADR is nothing that's trendy. It's very traditional. It's something which, unfortunately, too many of us have abandoned, possibly for good reason or for bad reason. But I think that what you need to take a look at is the ABCs. The ABCs that we have are attitude, behavior, and culture. And very definitely, if you have a bad attitude and bad behavior, you will have a bad culture. On the other hand, if you recognize that what it is in your client's best interest is to be able to resolve a dispute and resolve it on a timely basis, I think that you'll see quite an advantage. I would also indicate to you that the advantage that you see, and one of the reasons that I always like to, in the mediations that I do in the commercial list, is get the clients in personally as soon as possible, is to review with the clients where they want to go, where they think the matter is going to go, and what they would actually like to have. And we reach a consensus very quickly that what they would like to have is a tailor-made solution. That tailor-made solution, of course, is something that I indicate to them that if they can have a better solution on an early basis, rather than going through the whole court process, and eventually a year from now, 2 years from now, and in some cases 5 or 10 years from now, coming up with a decision perhaps confirmed on appeal or overturned on appeal, they're much better off. Therefore, on that basis, they're probably better off, and there's a reason to pay their counsel, if counsel are instrumental in achieving that result. They're a good reason to pay that counsel more than they would pay counsel if they went all the way through the trial process. Think about it for a while. Think about it in particular if you are counsel in the matter. The object of ADR is not to cut out the fees of lawyers, but it is designed to have your clients happy about the situation and you rather happy about the fees that you can charge. Therefore, take a look at your own practice. I did a very scientific survey. I got the answer that I wanted with the first person that I asked. So I didn't go any further. This person, a very skilled, able lawyer, acts for both plaintiffs and defendants. I asked what was the percentage of cases that he was involved in that settled for the wrong reasons. Because one of the parties died, one of the parties ran out of money, or one or both of the parties just got so sick and tired of the matter that they decided to abandon the matter. He said 50%. Think about your own practice. I can guarantee you that the people that you resolve in that particular way will not be repeat customers. What can you take a look at? Well, take a look at the practice direction, and I would say to you that the copy that Don held up was my copy. I think I'm the first person to have received a copy of the practice direction in the ORs. If you take a look, and it's at the very front of your material, you will see a lead-in introductory review of matters, giving you the rationale of why ADR now, why ADR with a court-annexed flavor to it. The one thing that I would like to emphasize is that this program for participation is voluntary. The only thing that is possibly not voluntary is that you will receive a Form 1, which is a very persuasive invitation to come to an ADR session to see whether or not your case is suitable for ADR. There is, of course, a requirement that you forward a copy of that on to your client, so that your client knows that there are possibilities of resolving a dispute other than going to the mat in a bloodbath a year from now or 5 years from now. That is Form 1, the letter that you get. It briefly reviews the type of ADR facilities that we do have. And it emphasizes, of course, that the solution is possibly tailor-made. At that time, there is a requirement, if you have been selected for the ADR process, for you and the other counsel to meet and confer, keeping in mind that this will be after a statement of defense has been filed. So any matter that goes on default, we don't touch. However, there is a requirement, if there has been a statement of defense filed, for the parties to meet and confer, for counsel to talk about whether or not this matter should proceed any further. And it may very well be that in accordance with that discussion, the parties will be able to report back to the ADR Center, thank you very much for the invitation, but it won't be necessary because we've looked at the matter and we have in fact worked out a negotiated settlement. Surprise, but very helpful. If you're not able to work out a settlement, then the next stage is to come into the ADR Center for a review. Now, do you have to go through the ADR Center if you want to have a mediation, conciliation, mini-trial, neutral evaluation, or any of the other spectrum of matters that we're suggesting are available? Absolutely not. There are many private ADR providers in the province of Ontario now, and those people are well able to deal with matters if you and your colleagues on the other side wish to go outside of the ADR Center facilities to have that dealt with. And we would invite you, in fact, we would encourage you to use the ADR providers outside of the center. In your booklet, there are a list of people presently on the roster, thanks to the Canadian Bar Association. That will be supplemented from time to time with additional people who will be registering with the center. let me emphasize that with respect to appearing at the ADR Center for an assessment, it is expected that you will tend as counsel, as advocates, with your clients. And if there is some reason why you cannot attend with your client, then it is expected that you will notify the ADR Center well in advance of that situation, but come to the ADR session with full authority to settle. In other words, we want the parties to come to that session with the possibility of that providing the working session so that the matter can in fact be resolved at that time, or with some additional homework, going back and having another appointment, or resolving it outside on your own. I'll turn it over to Nancy now.
We'll save Nancy for the bad.
Oh, sorry.
We'll save the best for end. What I want to do is my Ross Perot number on a little bit of showing you how we get to the numbers and the center. Let me talk to a little bit practicality. The center is located at 77 Grenville Street, which is where the provincial archives are. That's just north of College, and it's the Women's College parking lot. Women's College Hospital parking lot is on the north side of the street. The center is on the south side. It's a pleasant stroll on a nice day, and it's a $4 cab ride from downtown. But it is, the center is located on the 8th floor, and this is the rough layout of what it is. And you'll see that there are a number of not only boardrooms but breakout rooms. It feels a little bit like a special examiner's office, but the thrust of it is that it is a place where you come, you negotiate. If you've got to go off and chat alone and come back, so be it. And so that the whole thrust of the center is to make those kinds of negotiations fruitful and available. So that's the center, and that's where it is. Now, what cases, that's the easy part. I'm not sure whether, are those showing up on the TV screens at all? He's trying, he says he's turning up in any event, apparently it's too light in here, and if we kill these lights, I'm not sure what happens. That you can pick up the overviews afterwards. That's one of the bugs we're trying to clean out. In any event, this shows a case load overview, and what it shows you is in 1 year in Toronto, the various kinds of cases. If you remember when you do a Form 1 under the case management system, you're required to tick off the type of case. They kept statistics on the type of cases. The long line is the collection cases. Now, what percentage of your collection cases go to trial or anything else or aren't default judgments? So in a sense, collection skews everything. But when we come to the other kinds of cases that you're used to dealing with, tort cases, for example, motor vehicle is the large portion of it, but you can see that in Toronto there was just over 5,000 motor vehicle cases and 1,000 involving the Family Law Act. By definition, this project does not deal with either of those types of cases. So there is no, if your case is a motor vehicle case, you're never going to come and see us unless both of you decide you want to, or you get there some other route. The system is not going to select a case where that is chosen. That's the first little bit of news. Similarly, if your case is a family case of any nature, divorce, custody, whatever, there is a pilot project in Hamilton dealing with alternate dispute resolution there, mediation. You are not going to come to this center on a family matter during the pilot project. So those two types of cases are gone. And collections, to a large extent, yes, will come, but only where there's something to talk about, as opposed to I can't pay, unless, again, where it's an interest thing where I can pay if you give me some time, and here's how. And again, collections you can see in contract cases. Otherwise, wrongful dismissal is relatively small. It's about 2,000 cases, but that's the kind of case that this place is optimally designed for. Landlord and tenant matters are eligible as our breach of trust, but again, this scale, check the scale at the bottom. In fact, these are relatively small. It looks like a large number, but the bottom scale changed. A little bit of just information for you on the way by. This is the 3 tracks that you see in case management, just to give you some sense of what portion people are picking standard track, how much fast track, and how much complex. So you see that there's a fair number of complex cases, but when you get into some types of them, for example, collections cases, nothing's complex apparently, and very few wrongful dismissal. So again, fast track is red. You can see that real property, most people pick fast track. They want their deposit back, perhaps. Other cases, again, not many are complex. That says to me that not many cases are necessarily so complex that they couldn't be dealt with in this process. Okay, now some Ross Perot math. The total number of cases a year ago that went through in Toronto started 40,900. These numbers are 2 years old, but it gives you a sense. 40,000. We take out motor vehicle collections, and that leaves us with about 17,000. We pull out wrongful dismissals. I'll show you why later. And that leaves 16,000 cases that are eligible in the sense that they could be selected for this project. Of those 16,000 cases, we're going to pick one case in 10. We're going to pick any case whose number ends in 5. Remember, case managements are zeros. If your case number ends in a 5, you're eligible for this project once a statement of defense is filed. So if you want to watch at the counter, make sure you don't get a 5 or wait till you get a 5, your choice. We're going to pull 1/2 of the wrongful dismissals. If you got an odd numbered wrongful dismissal case, you're in. So 518 cases that would be. So that gives us about 2,100 cases that would be eligible. That's the number of cases started. The problem is, and I've used 50%, John's right, the number, and I was amazed at this number, it's actually between 30 and 40% in Toronto, a defense is filed. 60% of the cases started, no statement of defense is filed. You figure it out. Think about your practice. That's so 60% of the cases either they can't find the person, they turn out to be bankrupt, they turn out, whatever reason. Yeah, well, the statement of claim was so you got to move for summary judgment. I don't know. So that means I got 1,072 cases that will be eligible. Now, I had to throw in some ray days. Your number used to be 30. I raised it to 40. There's 160 working days available without holidays and whatever else. 2 cases a day for 3 dispute resolution officers. You'll hear about them. That gets me 960 cases, plus the project manager who will do about a case a day. That's another 160. And then you've heard the commitment today, and I want you, I know that the Chief Justice stands by it, and I know Justice Campbell is going to as well. It is expected that this center will be both judges and dispute resolution officers who are talented, trained people who are facilitators and know what they're doing in mediation. The judges are people who will have taken the appropriate courses and have demonstrated an ability, but they're going to work together. And there should be no stigma as to which kind of person you get. You're going to get somebody who is skilled for the type of case you've got, and if they recognize that they're not, then they might well refer it to the other side for whatever reason. We are going to have someone who is going to be a wrongful dismissal expert. We're going to have someone who has been in the construction industry and knows something about that industry so that they will be able to cut through a lot of the what's a judicious word? Complexity. Thank you, Igor. That means I've got a total capacity of 1,300 cases, 1,072 are new, and backlog in cases that you want to have get there, you and the other side all agree, or a judge agrees, that's another 250 roughly. That capacity is there. The numbers are flexible. It's going to take, it is a pilot project. We're there to find out, but we think it will work. And so that's the numbers. Now, you'll find in your material paper that I roughed out, I forget what letter it's at. It's G, I think, because you got a supplementary page. I gave you one that was wrong. The types of cases that are eligible I've told you about. How a case is selected, there is a system called Sustain, which is a computer system that is operative in Toronto and both courthouses, and that system will churn out every week a list of the cases where a defense has been filed for the first time, and that will generate the list that results in a Form 1 coming to you. Now flip to the back of the practice direction, you'll find a Form 1. It's at page A9. And there's also later on in the book some samples that I tried to fill out by hand. They are not very pretty, but they're at H1. H1, and we haven't yet determined the pretty color, but you will receive something that is colorful in the form of that you see at H1, a Form 1, and that will be mailed to you by the center, and that will tell you that, surprise, your case has been selected and you're in. Mr. Justice, it tells you the day that your session will take place, and that in a sense is like an examination for discovery being scheduled for you on a preemptory basis. You and your clients always seem to be able to make a discovery, you should expect them to make this date as well. And you'll see in the square box on page H3 the warning to you that you must give your client a copy of this. And you may want to fill in, Jim, have you got your practice? It's up there in the... I've buried it. There are 2 blanks that you might as well complete it so that you've got a complete practice direction. You'll see on H3 the 2 blanks. It should now read 16 OR, 3rd, and the page number is 481. You may want to load this on your machines at the office, especially when you come to part 2. Now the thing that you need to worry about is, first of all, that there is going to be a need. You can't just say, okay, I've got that date, I'll put it in my book and show up. That's going to be the thing that's going to, those of you who've practiced in the commercial list know how you used to be able to go and ask for an adjournment and sometimes get it, but there was a learning curve for the profession to understand that when you set a date, you meant it. Well, that's what's happening here. You've got a date that tells you that's the day that your session is going to take place, but you have to have done things before that date, and so you're going to have to schedule backwards, working from that date. So what you need to know is that you have to schedule a meeting with the other side, and you have to fill in a Form 2 describing what happened at that meeting a week before the session. So you've got to file a Form 2 1 week in advance of your ADR session. So you see the calendaring you got to do? Not only do you have to fill in that form, but you have to have already met with the other side. So what I'm saying to you is we're going to give you a fair bit of lead time, but don't waste it. When you get the notice, right away, schedule a meeting with the other side. Get it over with, because otherwise you're going to have egg on your face when you've given your client notice of a date, because the rules require you to give your client notice, and then you get there and say, well, we didn't meet with the other side, and so this is a waste of time, we have to come back another day. Don't do it. Be forewarned. That's why you came here. That's what you paid your bucks for today. Form 2, have a look at it. It requires you to list the documents that matter, not everything that, it is not a haystack case. It is, this is the promissory note and this is the agreement or not. Mr. Justice Farley has told you that you should be there with your client. Let me talk to you a little bit about the kinds of cases and what's going to happen. The wrongful dismissal cases, it's going to be every other case. And statistical analysis, from our point of view, this is a pilot project. If the bar doesn't like it, if the clients don't like it, we'll fix it. If we can't fix it, somebody will kill it, Treasury Board or otherwise. But we're going to need a fair bit of reaction from the bar. And so you're going to have a little bit of extra inconvenience in the sense that somebody is going to give you a questionnaire and say, would you mind telling us, did you settle your case? What did you like? What didn't you like? Did you have enough time? Not enough time? Whatever. Help us out. Fill those in if you can. It will make your practice in the future easier, and it will help us to evaluate the process. I want to talk specifically about one type of case, and that's construction cases. Masters, Sandler, and Clark are here today, and they and I have had some discussion about how we're going to make the best use of the ADR Center in construction cases. and it is still being worked out, but I think it's fair to say that we anticipate that in cases where it's a two-party lawsuit, where it's not a mega case, that the masters will invite, encourage, cajole, or send the parties to the ADR center to meet with the construction mediator there to try and resolve those cases. That will get them out of the standard proceedings. It will free up masters' times for the other types of cases. But that's still being worked out. It's being worked with the construction bar, and those of you in the construction bar, and I see a fair number of you, your input into that element of it is welcomed, and we're looking forward to it. I think my job was to deal with Forms 1 and 2, and I have, and I'm going to turn you over to Nancy Spies, who is another member of the steering committee, to tell you what happens once you get to the ADR session. But the message that I want to give you again, and can't stress enough, is you've got to make sure that as soon as you get a Form 1, you gear up, you get it in so that you're in a position to file a Form 2. Because if you look at a Form 2, that's in effect your pretrial memorandum. That's what the mediator, that's what the person at the ADR center, that's what the DRO is going to look at and in effect understand your case, what's at issue in your case. If you haven't done that, you're wasting everybody's time and your client's money. Nancy, you're on.
Before I get into the session, I'd just like to begin by reviewing again the manpower so you'll know who it is you might be meeting when you attend your ADR session. As Don has said, there will be a full-time project manager who will also do some of the DRO work. And by DRO, we're referring to the dispute resolution officers. That's a term that we came up with at the steering committee. And we will be hiring 2 full-time dispute resolution officers. The applications are being reviewed and the interviews are being conducted currently. We expect that those people will likely be lawyers with background in mediation. We will also be hiring part-time DROs. We have budget for 2 part-time DROs who we expect will be non-lawyers. One will be focusing on, and it may not be one, but the equivalent of one part-time will be focusing on construction lien matters, perhaps a senior management person in the construction lien industry, and another focusing on wrongful dismissals, perhaps with a human resources background. And it's expected, and that's one of the things we'll be assessing, that trained non-lawyers will be as effective and perhaps even more so in particular types of cases as trained lawyers in assisting the parties in reaching a resolution. The DROs, the project manager, and the judges participating in the project will also be trained in advance of the project getting underway, which I guess we haven't addressed, but we hope to have it up and running later in the month of April if we're optimistic, early May if not so optimistic, realistic, yeah, reality check. When you get to the ADR session, you'll have had your meeting with the other side, you'll have filled out your Form 2, and you will be meeting either with the project manager, a DRO, or a judge. And the first part of the session will be an ADR assessment, which is a defined term in the practice direction. And really the purpose of that is to consider the suitability of ADR for the particular dispute and also consider what process should be employed. And we're hoping that if the decision at that point is that it's a case that is suitable for ADR and you're looking at mediation, perhaps with a component of or an alternative as neutral evaluation, that can be done basically on the spot, either by the person who's in attendance, or if it's a neutral evaluation, you want a judge's views, that a judge will be available and you'll be able to go that route. If you've are of the view that there's an issue that needs to be dealt with and you want what we called a mini trial, that will have to be arranged for a later date, and it's contemplated that then the parties would prepare and come back for that at the ADR Center. There are, of course, possibilities of arbitration outside the center and private service providers outside the center, and that is, again, something that can be canvassed at the ADR assessment if that's there's something that you want or a particular person that you need to help you that is not available through the Court-annexed ADR service. Now, the other thing that you'll have to do in advance of the actual ADR session is complete a Form 3, and if you could just turn to page A14. And that will be a form that you'll be signing on behalf of your clients in advance of the session and filing at the ADR Center. And it confirms a number of things. First of all, the absolute confidentiality of the ADR session itself and the documents that you produce. Obviously, if they're otherwise discoverable, then if the case is not settled, you'll have to produce them again. But for example, witness statements, anything that you want to bring with you to the session is protected and confidential. The records, recollections of the judge or DRO are obviously to be kept confidential, just as a pretrial. And also there is provision for immunity. The same immunity is provided to the judges of the General Division. And in light of Genevieve's comment this morning, the only answer I can tell you at this stage is that as a matter of law, the DROs and the pilot project director will be employees of the ministry, and the DROs will be reporting, at least in the first instance, to the project director. In cases where you've decided to use a private ADR service provider, it may well be that you will want to enter into a similar agreement. I think many will have agreements of this sort, but you'll want to make sure, if you're going that route, that you've entered into an agreement concerning confidentiality. Now, paragraph 6 of the practice direction talks about what is recorded with respect to the ADR session itself, and it and paragraph 7 deal with Form 4. If you are fortunate and you reach an agreement during the course of the ADR session, it has to be reduced to writing at some point. It may or may not be during the session itself. It certainly will be encouraged that you do that, and it will be something that is signed by the parties at that date. In complicated cases, obviously, you're going to have to work out something, and agreements will be signed following the session. But in all cases, whether you settle before, during, or after the ADR session, the practice direction provides that you're to give the ADR Center notice of the settlement within 10 days. And that, of course, is going to be extremely important for us as we evaluate the success of the project. And so that's something that the ADR Center staff will be following up on, and obviously expecting council to cooperate in that. Paragraph 6.2 of the practice direction again confirms the confidentiality of the ADR session. And so if no agreement is reached during the session, then no record of the ADR session is going to be available to a trial judge who ultimately deals with the matter, other than the completed Form 4, which actually has a number of purposes, but it's at page A15 in the materials, and it's the Certificate of Inability to Resolve through ADR. And it's dealt with more expressly in paragraph 7, and I'd like to take you through that. It's the persuasive element of this practice direction, which we've stressed is voluntary, but there are certain things that you will have to do as a minimum. And paragraph 7.1 of the practice direction provides that you will not proceed to trial, and we're dealing here only with cases that have been referred. So obviously this is a case you've been referred to the ADR Center, and your case will not proceed to trial unless one of two things happen. If there's been no ADR session at all, you've completed Form 4, and all parties have to complete it and file it at the ADR Center. Or in the alternative, if there has been an ADR session, the form has been executed on behalf of at least one of the parties and filed at the ADR Center. And in both cases, you'll need to file it along with proof that it's been served on the clients. Now, what this means is that if an ADR session is held either at the ADR Center or by a private ADR service provider, then all you have to do, and the case hasn't settled and you want to get on a trial, all you have to do is complete Form 4 that it's been tried and not succeeded, and then indicate whether you've tried ADR through the ADR Center or through a private service provider. Again, that information will be important to our evaluation. In the cases where no ADR session has been held, neither through the ADR Center nor privately, then this form has to be filed by all of the, and signed by all of the parties. And then obviously you're checking off the box that an ADR has been considered but unlikely to succeed. And the reason that it's different in this case and that all parties have to sign is that if one of the parties wants to go to ADR at the ADR Center, and this would obviously only work at the ADR Center, then everyone has to come along at least for one session. Otherwise, so it's designed to ensure that where there is at least one party willing to settle or discuss settlement, that you go to one ADR Center. So to that extent, there is a compulsory element in the practice direction. Unless everyone agrees not to, and then of course this has to be provided to your clients, and the idea there was to ensure that clients, again, they've already received the Form 1 and have some idea of what ADR is all about, and now if they're getting a certificate that's been signed by all counsel saying that it's not going to work, that obviously it's a method of making sure that you're accounting to your clients and that the form is taken seriously if you're going to opt out of the system. You'll see as well that Form 4, if you turn over the page to A16, provides that the legal or factual issues that remain to be outstanding are to be determined at trial. Now that could be completed at the end of an unsuccessful ADR session, or it could be prepared by the parties if they've decided ADR is not suitable for the case. And that obviously isn't intended to bind you at trial, because often these forms will be filled in at a very early stage, but it's hoped that that will help focus the cases going on, the discoveries in the trial, and perhaps save some time in the long haul. And we've also asked that the parties estimate the time that the trial will take. And again, that's a dual function, A, to assist the court, and also to bring home the cost of what this case will take if it goes to trial if it's not resolved. And again, perhaps a reality check for the clients who are gung-ho about going on to trial. The practice direction encourages in all cases that a joint certificate be prepared with a joint set of issues, but where that's not possible, then you can file them individually. The final thing that I wanted to deal with is the question of costs. And the practice direction in the preamble says that it's not anticipated that the power to award costs pursuant to Section 141 of the Courts of Justice Act and Rule 57 of the Rules of Civil Procedure will be exercised in relation to ADR sessions attended by the parties or counsel appearing on their behalf. So in other words, where the parties cooperate and at least attend the first ADR session, there will not be any cost consequences, either of the session itself or the fact that it hasn't resulted in a resolution. But the practice direction doesn't deal with this, but it seems to me that given that language, that where one party fails to cooperate, just shows up because they have to, but is really not taking the process seriously, and that lack of cooperation is not justified on the facts, that might be something that you as counsel can argue down the road at trial as a method for arguing a higher scale of costs or extra costs in terms of preparing. So it's not provided for expressly, but it certainly is something that I think as counsel you can look at, particularly as there are more recent cases where the conduct in terms of not settling sooner is being used by judges as a basis to award solicitor-client costs. So I think that's something that you may want to bear in mind as well as practitioners. And those are all my comments. Thank you.
Thanks, Nancy. Mr. Justice Farley, if you want to deal with the last paragraph.
The last paragraph is this. There is a users committee, and that will be set up. We have found the concept of the users committee extremely valuable in the commercial list matters, and we intend to have full consultation with the bar through the users committee, which will facilitate both those types of criticism that might be referred to as constructive, and also filter those through that really are destructive criticism, because even destructive criticism is very helpful. We know whether or not what we're doing is the appropriate thing. I would suggest to you that the setup of this particular pilot project is not something which we are putting forward as the absolute answer to everything. But I think that you will see that what we have done, very careful consideration and a good deal of consultation with outside people, is to devise a scheme that we think will work. It is probably not the only holy grail. In a lot of ADR situations, you get people continually looking for the one holy grail. In ADR, there is no one Holy Grail. There's perhaps 150 different Holy Grails. We think this is a pretty good one. If in fact it is not something that works as well as we would like to, there will be adjustments to it, and your comments will be very helpful through the Users Committee in dealing with that matter. Lastly, let me comment about how can you as council prepare yourselves for ADR as ADR advocates representing your clients. As I've said, what you see in an ADR situation is something that's a little traditional. When you get down to it, you will see that what you are involved in is really nothing new. You will just see that it's presented in a slightly different form, a better checklist, a situation in which you can sort of go back over and review matters. Let me suggest to you that it would be extremely helpful for you if you took a look at particularly in the mediation side of things, if you took a look at the Harvard Principled Interest mediation sessions reflected in books by Fisher and Urey, such as Getting to Yes, Getting Past No, and Building Relations. And with respect to ADR in general, an excellent book is the Goldberg-Sander book, Dispute Resolution, put out by Little Brown, and it costs about $40 US. And lastly, Linda Singer's book on Settling Disputes. Thank you.
Thanks, Mr. Justice Farley. If I could invite the next panel to come up, who are going to deal with following up on those last remarks on representing your client effectively at an ADR session. Some thanks along the way. John Carson, QC, kindly agreed that we could reproduce his material at Chapter C, and I recommend that to you as an overview on where we have been in Canada up to now. As well, Allan Stitt put in some material for us dealing with the assessment of the pilot project, and you'll find that at tab I. I ask you to note that you can buy tapes of today's program at the bargain basement price of $34 or $17 a half. And don't forget to fill in your questionnaire and to pick up your copies of the overheads on the way out. I will pick up my garbage here. And turn you over to the individual. Any of you who have served on committees know there's somebody who has to do a lot of the hard work to make everybody else look effective. Brian Gover has been the representative of the ministry who had the joy of going through, I think I lost count at 13 versions of the practice direction and keeping it going and bringing it to fruition. And Brian is going to chair this panel, and so I'll turn you over to him now.
Thank you very much, Don. Although the practice direction contemplates several ADR processes, including neutral evaluation and mini-trial, it is anticipated that most ADR sessions at the ADR Center will involve mediation. Paul Iacono, from a litigator's perspective, what are the principal ingredients of an effective mediation, and how do you go about effectively representing your client at one?
When I think of mediation and when other lawyers ask me about it, I always refer to what I call the 3 Ps: preparation, participation, and patience. Now, as you've heard today, ADR is simply another form of advocacy, and it should be approached as such. The main advantage of the process is that you, as an advocate, get to sell your concept of the case directly to the opposing litigant. no lawyer would go into a trial and conduct an examination in chief or a cross-examination without having thoroughly prepared for it. And similarly, what you do every day in your work applies to mediations. Preparation begins with the practice direction, which sets out guidelines that have to be followed. The meet and confer rule is very important because counsel are obliged to get together with each other and outline the various issues that are in dispute. Hopefully, that will focus everyone's attention on what's involved, what they're arguing about, and ultimately, in terms of time, will shorten the mediation process. Once you've gotten through the meet and confer, then comes the Form 2, which is the way counsel confirm that they've met, lists what they believe to be the issues. Again, everyone's attention is focused on what's in dispute, and then a list of all of the documents that are going to be referred to is part of that Form 2, and it's submitted. The mediation summary comes next. And this is really counsel's first opportunity to persuade. Your persuasion is directed at the opposing litigant primarily, at opposing counsel, and to a certain extent to the mediator. It is at this stage of your preparation that the second P comes into play, and that is the participation aspect of it. Because keep in mind, the case is your client's. And what I like to do is, when I've prepared a mediation summary, I send it to the client. And I say, please take a look at this and tell me if you think there's anything else we should mention or any other facts or argument we should make. Now, if it's a very complicated case, I will do a draft, send it to the client, and invite the client to come to the office and work through it. That way, the client is buying into the whole process. And that's very important. In terms of preparing the client for the actual attendance, it's just like preparing a client to be a witness. The client has never been to one of these before, and you want to do your best to put the client at ease by stressing the informality of the situation, and it is very important that you encourage the client to speak up and participate in the process. People start lawsuits because they feel they have been aggrieved. They want someone to listen. This aspect of ADR, which I like to refer to as a catharsis, is a very important part of getting to yes. And that is why the element of participation is important. Sometimes if a client, in the course of speaking at a mediation, speaks too much, you just have to move them along gently to another point. But they've got to be there and they've got to participate. Now, another aspect that I want to mention, since I act mostly for defendants, I want the defendant to see what the opposing litigant is like. I want the defendant, my client, to know what caliber of a witness they're dealing with. Part of the practice direction requires that the client be in attendance. This is very, very important, because if the client isn't there, the catharsis doesn't take place. If your client can't be there, you should rearrange. I do not believe in mediation without the client. under the practice direction, if the client can't come and you can't rearrange, you are obliged to come to the mediation with full settlement authority. To me, this is an alternative, but it's not a satisfactory one, because it's the client that has to make the ultimate decision to settle, to resolve the dispute. It's the client that has to live with that decision, and therefore the client must buy into it. And if the client isn't there, it doesn't take place. So my advice on that point is attend with the client under all circumstances. Finally, patience. You cannot rush a mediation, and you must prepare your client that this is going to take a while. Now, as a young lawyer, I remember the late C.F. McMillan, QC, telling me that a lawsuit is like a cake, and that it has to stay in the oven for a precise amount of time, otherwise it won't be baked properly. Now, I didn't agree with him when he made that statement about a lawsuit, but when it comes to mediation, I can tell you from my experience, it is very, very true. Because different human beings take different amounts of time to deal with their whatever it is that's aggravating them. And until both of the litigants get all the poison out, you won't resolve the case. So you must be patient, and you must prepare your client to be patient. Many times, because I'm acting for defendants who are experienced litigants, they want to get to the bottom line and go home. And one of the problems that I have is holding them back. And that's where the patience comes in. And you just have to wait for the opportunity to close the deal.
Paul, you've spoken about a mediation summary, and the practice direction refers to Form 2. Would you advocate, in appropriate cases, filing something in addition to the Form 2?
Definitely. I do advocate that, because the mediator needs a roadmap of the case. Opposing counsel need a roadmap of the case. And by the same token, you need to know where everybody else is going.
Would you do that in every case?
I would do that in every case. And again, as I said earlier, I would have the client's got to buy into that. I would have the client participate in that right at the start. Do you want me to speak in more detail about what I would put in it?
This is called going extemporaneous, by the way.
When I'm doing a mediation summary or even a pretrial conference memo, I like to put it in letter form so that it tells a story, so that the reader finds it interesting. And I like to use little subheadings so that all the issues are touched upon. And I like to keep it no longer than 2 pages, because if it's any longer, nobody reads it. But I really do believe that it's an essential ingredient.
Kathleen Kelly, from a mediator's perspective, do you have anything to add?
Let me first tackle the issue of the mediation summary. And the mediation summary, in my perspective, is very important for at least 2 reasons. One, it properly briefs me as to what the issues are in dispute. And secondly, it also alerts me to any problems that might be evident in a case. Sometimes counsel provides mediation briefs that are 2 to 3 inches thick, filled, this is in personal injury actions, filled with all sorts of medical and expert reports. And I can tell you right now, the mediator doesn't need that information. It is more important that the parties have a complete handle on what evidence they've got and how they're going to use that evidence to their advantage. At a mediation session, it's helpful for the mediator to have a copy of it, because then when counsel A says, Dr. So-and-so said this in her report, counsel B says, that may be the case, but Dr. Zed says this in his report, and the mediator can say, hold on, show the other party exactly where in the medical reports you're referring to and how that supports the position that you're holding. What impact does it have on your case? And a lot of times there's still the spirit of puffery that goes on even in the mediation, so it's important that the mediator be able to say to the counsel, and oftentimes it's senior counsel, it's important that the mediator be able to say, please provide the basis for the view that you hold. For example, if you're making a claim, and this happened very recently in a case I had, there was a claim made for lost earnings, and the only thing that was submitted to support a claim for past and future loss, and they were significant amounts, over $100,000 was being claimed, was a letter on a computer piece of paper with a name of a company stamped on top of it saying that the person had worked there for so many hours over a certain period of time. There were no tax returns, there were no T4s, there was none of the other type of evidence that's needed. And quite frankly, it doesn't help anybody move the process along in terms of the mediator, but it also alerts the other side to the fact that maybe you really don't have such a very strong case with respect to loss of earnings. So it's the material's important, but remember, it's the other party that you're there to persuade. The mediator is just there, or the DRO in the case of the pilot project is there to manage the process, to keep the parties talking, to help narrow the issues, and not to tell you that your evidence is bad. That will come out. If your evidence is bad, it'll come out and the other counsel will pick it up. But don't embarrass yourself by taking into a session material that will not support your position. It's really important that the lawyers who go to these sessions, and in fact go to any mediation session, know not only the strengths and the weaknesses of their own case, but that they also know and are very realistic about the strengths and the weaknesses of their opponent's case. Because it's only then, when you've got a full picture of what you're facing, that you can properly prepare for one of these sessions. It's critical at the beginning of the session, and the mediators will be doing this. We do it in private practice, and the DROs and the judges will be doing this in their sessions. They will be setting out the ground rules for the conduct of the sessions. Why are ground rules important? Simply because there is no body of law or rules that govern ADR sessions, mediation sessions. So they have to be set out and agreed to prior to the session commencing. And if that's done, you're going to avoid the problem of counsel trying to speak over each other and your clients trying to advocate their case when you're trying to perhaps advocate a different perspective. In order that the sessions be as productive as possible, I would really urge counsel to discuss with their clients ahead of time and be prepared to discuss in the session the rational basis for the claims or for the defenses being advanced. You really have to know what the building blocks are that your case rests upon. And it's in knowing what those are that, and articulating those, that the process can be moved along.
Mr. Justice Blair, in the context of court-based ADR, do you have any comments about what the other panelists have said concerning the components of an effective mediation?
I think that Kathleen makes a very good point when she emphasizes the role of the DRO or the judge in this context of a mediation, at least, and that is that the role is that of a facilitator. The objective is to enable the parties to arrive at their own solution rather than to impose a solution. And that brings up the distinction between this type of mediation and the normal kind of pretrial that we're all familiar with. There are various ways to mediate, and a good pretrial is in fact one way to mediate, but it's more rights-based than interest-based, and you've heard that distinction made earlier. today. I think it's not contemplated that the process at the ADR Center will replace the process of the normal pretrial, and that the mediations which take place there will be more interest-based mediations. So you need to remember that in your capacity as advocates, that you're not really attending the session to persuade the DRO or the judge that your case is right or that your case is wrong, but you're there to try to work out a resolution with the other side. And I agree with the comments of both Kathleen and Paul with respect to the preparation of the mediation summary. It's absolutely essential that the neutral person has an idea of what the case is about, but it isn't necessary to drown that person with volumes and volumes of paper. I think Paul was quite right when he says that the mediator needs to have a roadmap, but we don't need the 4-volume Rand McNally version of the Atlas of the World for every case. And oftentimes it's more helpful to the mediator to know less about the case than to know more about the case, I think. So I agree with both of those comments with respect to that. In terms of your roles as advocates, you've heard many times already this afternoon that there's nothing new here. That really what ADR involves is a refinement and maybe an institutionalization of forms of advocacy that good advocates have used for generations and generations. And what I think is most important in terms of representing your client effectively in this kind of context is that you learn to be flexible, that you learn to be creative, that you learn to apply a certain amount of ingenuity when you come to these sessions in order to help your clients find a solution that fits their particular case. That's the real beauty of ADR. It has so many options in terms of techniques that are available to it. And there have been a lot of analogies this afternoon with respect to that too. Mr. Justice Farley calls it the Holy Grail. There are 150 Holy Grails. Being so taken as I am with nutrition, I like to think in terms of a smorgasbord. And what ADR presents is a whole smorgasbord of techniques from which you can pick and choose the technique that most closely and that best suits the particular dispute that you have at hand. And so you've got to use your skills as an advocate to be able to pick and choose the right techniques, and that will be an important facility for counsel to learn in this context of applying ADR. Finally, I just want to add my voice to those who emphasize the importance of having the clients at the session. I think that's absolutely essential, that the client be there, and if the client is a corporation, that the person representing the corporation who is there has the authority to settle.
Thank you. Paul, to return to one of your 3 Ps, preparation, could you tell us whether your preparation would be any different if you knew in advance that the session was going to be conducted by a dispute resolution officer rather than a judge?
The short answer to that is it doesn't make any difference. Your goal is the same. Many mediators who are good mediators are not lawyers and are not legally trained, but they come to a mediation very well prepared. They at least have an understanding of the legal issues and know how to deal with them. As was mentioned earlier today, some of the DROs in the pilot project will in fact have special expertise in such things as construction, wrongful dismissal, and I would assume that someone who's mediating a wrongful dismissal dispute would know something about pensions and tax implications. So your preparation is really the same.
Let's discuss the role of the mediator for a moment. Kathleen Kelly, do you have any comment on mediators telling lawyers that they are wrong, and would you anticipate this practice to occur at the ADR Center?
I would not anticipate the practice to occur at the ADR Center, and I would say you're going into a minefield of problems if you tell a lawyer that the lawyer's wrong. So don't do it. It's not going to be done. I don't think people do it in private practice. It's not a way to keep the process moving, and it's not going to secure or keep the credibility and impartiality of the mediator highlighted. It's far better to ask questions like when, how, where, why, how. Those sorts of things. I think I may have how'd twice. But it's not the mediator's role to critically challenge the advocate as in being critical of the advocate. It is, however, the mediator's role to constructively and critically challenge the views that are taken. There's two ways of handling it, too. There was a reference earlier of the passive style and the active style. Quite frankly, if the passive style works in a mediation, I run with it. If an active style is required, I run with that. But more often than not, in a joint session, which is when everybody is in the room, when all the parties are together, you're probably better off to have a passive style rather than attacking what everybody is saying. However, when you get into a caucus, when you're meeting separately with one of the parties and their counsel, then you can become quite active. And I would anticipate that that will happen, that the DROs or the judges will ask you what the basis is for the opinion or for the view that you're holding, and that the neutral will not be quite as soft or as passive as when all the parties are present, because there will be those things occurring that were referred to earlier, like reality testing. And sometimes mediators will say to the parties, now how are you going to establish that in front of a judge or in front of a jury? And then that causes everyone to pause and reflect as to whether what is being projected is real or not real. And sometimes parties will want a mediator to be more active or more passive. The other thing that a mediator or that the DRO has to emphasize, or the judge has to emphasize, is that the parties are there with their counsel, and that it's not our job as neutrals to denigrate the role of counsel, but rather to support counsel and remind the parties. And this comes up sometimes in private mediations, and it may come up again in the Court-annexed project, where parties are going to want to get a second legal opinion from the DRO or the judge. And in that instance, it's really important and critical that the DRO, the judge, the mediator says what their role is. And again, that would have been set out in the ground rules, but it bears repeating. If a party says, what is your view as to how I would fare at trial? You just turn the question back over and invite the party to ask their very capable and competent counsel to explain that to them, because you don't want to tread on that very, very important line and the very important relationship of solicitor-client.
Mr. Justice Blair, do you have anything to add about the role of neutrals?
Well, I'm just sitting here wondering whether I agree completely with Kathleen about the use of muscle by the mediator, as Professor Emond put it, in terms of the counsel who are involved. I think there are occasions where you may meet with the lawyers alone, or one of the lawyers alone, and not with the client, and you may be in that context a little more forthright with your views on the merits of the case than you would be on ensemble, and that sometimes that's necessary to break log jams, particularly towards the end of the negotiations, because negotiations inevitably reach an impasse before they're finally settled. And somehow you got to break that log jam, and maybe applying a little bit of that sort of persuasion on the lawyer isn't a bad thing. I agree that you don't denigrate the skills, the techniques, the manner in which the counsel are representing their client, for sure. But in terms of the strengths and weaknesses of the case, I think you can point out to counsel in appropriate circumstances and in an appropriate way the strengths and weaknesses.
Paul, a comment on the role of neutrals.
Yeah, I just want to comment on what Mr. Justice Blair has said and following along what Kathleen has said. And although I know that as a mediator, Kathleen would never come out and say to somebody, you're wrong about this point, but in some cases, as Mr. Justice Blair points out, it has to be done. And sometimes in certain kinds of cases, at the outset of the process, when you're going through the process of selecting a mediator and you know that certain issues are going to come up, you want to select a mediator that has a certain expertise in the area and who won't be afraid to do what Mr. Justice Blair said has to be done at a certain point. Now, I've seen Kathleen do just that, but in a much subtler way by putting other issues out on the table. But at some point, if somebody has stated a wrong principle, it's got to be corrected. That's all.
Just trailing on that, though, it's not the mediator's job to do that work. That's why there's counsel there. So although you might be very tempted to do it if you are a lawyer and a mediator, it's dangerous, dangerous water to tread. And I would turn it over to the other counsel by a question or a comment such as, Mr. Iacono, what view do you have with respect to what Mr. Gover has just said? So turn it back to the counsel, let them do it so that the neutral doesn't become the sandwich or the bad person.
Well, we can disagree on that.
Judges aren't necessarily right or wrong about who's right or wrong any more frequently than anybody else, but I suppose they think they have the right to be.
Mr. Justice Blair, how will a mediation summary differ from a pretrial conference memorandum?
Well, we've already touched on that. I think the purpose of the mediation summary is to give a thumbnail sketch of what the case is about and maybe the road that it's taken to the point that it's at, but not to provide a detailed analysis of the merits and the strengths and weaknesses of the case.
If I could just add on that, it would be helpful, if not in the mediation summary, then certainly at the opening of the session, to know what stage the litigation is at and what settlement conferences or negotiations have taken place prior to the mediation. Because that alerts you to, if nothing else is said on the matter, it alerts you to what kind of a relationship counsel may have with each other.
Paul, a final note on mediation summary.
Just one comment that I'd like to make. I'd like to have a theme for the mediation summary. And the best way I can illustrate that to you is to take a real-life example. In a case where a middle-aged lady who had a very spotty work record and some pre-existing problems, gets in an accident, is injured, and lo and behold, 5 weeks before this accident, she started work at the best job she had all her life. And of course, her lawyer's building up a huge claim for loss of income. And in the mediation summary, you would simply outline all of her previous problems, her spotty job history, and you would put the defense position very concisely and where the defense is supported. But for the theme of that case, I used a phrase, "One swallow doth not a summer make." And of course, every time you use that phrase in the mediation, all of your arguments are repeated in the brains of the opposing litigant automatically. That's just another technique that I would add that I found useful.
Now, Form 4, the Certificate of Inability to Settle through ADR, requires the parties to identify legal or factual issues that remain to be determined at trial. Kathleen, how realistic is it to think that ADR sessions which do not result in a negotiated settlement will nonetheless serve to narrow the issues outstanding at trial?
In my experience, this happens in just about every case. In fact, I haven't had a case where people have walked out of the room and said, this was just a waste of time. I've done a considerable number of these cases, but it's not necessary to say anything other than that, just to let you know that it's not a matter of a few cases. And often counsel will say, you've helped us narrow the issues, you've shown us where there have, or the session has shown us where there has, where there's inadequate evidence, or where the evidence just isn't there to make out the claim that's being advanced. The other area too is that even though a full settlement can't be reached at a mediation, if a settlement can be reached on part of the claim, part of the issues in dispute, if they can be narrowed, and if closure can be brought to part of the claim, then I encourage the parties to do that and to sign minutes of settlement with respect to those items that they can agree upon. With respect to cases that must go on to trial, and there are cases that must. Certainly there are matters or portions of cases that can be mediated or negotiated, but sometimes there's sticky issues of law that for whatever reason the parties don't want to agree to take a unified position, and those have to go on to trial. Having gone through a mediation session, the parties are in a much stronger position to articulate not only for themselves, for their clients, but more particularly for the court, exactly what it is that they want the court to determine. And I think in that regard, these sessions will end up being very useful tools to help justice get moved along a little more efficiently.
Mr. Justice Blair?
Well, of course, that helps immensely in the processing of cases in the justice system in these days of limited resources and limited courtroom space and limited number of judges, because it allows the judges to do what judges are supposed to do, namely decide legal issues and deal with the cases that need to be tried.
The practice direction provides that cases may be referred to the ADR Center at any time following the filing of a statement of defense. That raises the question about the optimal time for an ADR session to occur. And Paul, what in your view is the best time for a case to be subjected to an ADR session?
I think the timing in every case is different. I can conceive of some types of commercial disputes where the issues will be crystallized in the pleadings. If you have a lot of factual disputes, I think you have to proceed to an examination for discovery to get everything out on the table. In the kinds of cases that I tend to deal with, they do require discoveries, and the best time, in my view, is after a discovery, but before a pretrial conference. Let me just sort of diverge here for a minute. A pretrial conference tends to crystallize issues. And if you attempt to mediate a case after a pretrial conference has taken place, the problem that you have is that you've had a judge tell one of the litigants that, you know, I think such and so is going to take place, and I think this is how this particular issue is going to be resolved, so that the other person is mediating uphill. I suppose one way you could get around that is have the judge that conducted the pretrial conference do the mediation, so that so that some of those issues could be softened somewhat. But it's very difficult to do a mediation after a pretrial. While I'm on the subject, let me just say that costs in all of this are a significant factor to the client. And I'm going to diverge for a minute because I think this is important. When the rules of practice were amended in the middle 1980s, the thrust of it was to front-end load litigation so that issues would come to the fore sooner and cases would get resolved sooner. But it didn't happen. because too much emphasis was placed on the pretrial conference. And for some reason, lawyers tended to become very indecisive, and they wanted to wait to hear something from a pretrial judge before they made any decisions about cases. And that's part of the reason why we're here today, because fewer and fewer cases became settlable at or after examinations for discovery. And unless we do something about it now, unless we take this opportunity to use ADR, our courts are going to become paralyzed. The clients that I act for like ADR because they see it as a very cost-effective way of dealing with litigation. Plain and simple, they get the biggest bang for a buck, and they get to close files. This pilot project that we're undertaking now is a good one, and I think that once the profession buys into it and realizes that it's a viable alternative to the adversarial system, it'll work quite smoothly.
Paul, let's turn to patience in the remaining time. And one of the objects of the pilot project is to determine how much time should be set aside for ADR sessions. From your experience, how much time should be set aside for a session? What role does the type of case play in that determination? And will the meet and confer requirement in the practice direction have any effect in abbreviating ADR sessions?
I think that if counsel are faithful to the meet and confer rule, if they approach each other on an open-minded basis, discussing all of the issues, I think that that will considerably shorten the mediation process. I think that certain cases will require shorter time than others. I think that commercial cases and wrongful dismissal cases where there may be one issue, was there enough notice, for instance, I think those cases can be handled quite nicely in, say, 2 or 3 hours. I always tell my clients, look, we're going to be here all day. This is going to take all day. I prepare them for the worst. I like to start around 10 o'clock in the morning, and I think it's a very serious mistake to have an intermission, even for lunch. I think you've got to keep everybody talking, and you've got to stay there until, until the deal is done or until you've hit the wall. If you allow for a long break in the proceedings, people start thinking about what's happening, and they'll think of 1,000 other questions to raise when they come back, and you'll never get to yes. So I'm a great believer on keeping everybody there until it's done, and warning everybody in advance that it's going to take time.
Mr. Justice Blair, do you have any comments concerning nutrition or anything else arising out of what Paul has just said?
Yes, in fact, I do. I agree with Paul that these mediations take on a dynamic of their own, and that it's very important to be able to ride that dynamic through to a settlement. There can be a case made for lunch, though. And one was made, in fact, just last Friday when I was mediating a matter at a law firm, and it was a kind of a pretrial mediation. And it lasted after the morning, and the parties had got all their frustrations off their chests, and we talked about the case a little bit. It was lunchtime, and we broke for lunch, and I said sotto voce on my way out that it didn't seem like a black and white case to me. And when I came back, the parties were talking, and the case settled. So lunch worked for me. I don't know whether the parties had much lunch or not.
Kathleen, from your perspective as a mediator and a litigator, how much time should be set aside and what accommodation should be made?
Okay, I want to address two other things first, if I may. One is to just draw attention to what Justice Blair said with respect to the passive approach of the mediator, which he employed, which got the parties going again. And that's certainly a case where a properly stated comment can really move things along. And of course, coming from somebody with the authority that he holds in his other job, being sitting on the bench, that carries, I would suggest, a great deal of weight with the parties. But I also think that there are probably a lot of litigators in this room that are thinking, now we know Paul Iacono's style. He wants them to negotiate and ultimately get a settlement through exhaustion. But that isn't the way he that isn't the way he operates, in fact, from my experience sitting as a mediator when Paul has been before me. And mediation is not meant to be a case where you really run the parties all day and not allow them to have any refreshments. There was a case that I was doing about 3 years ago where it had become particularly obvious that one of the counsel required nourishment, because when one very senior counsel said, I will pay $75,000 for that claim, this fellow was sitting with his calculator and he says, well, it's really only $72,359.48. And that was a mediation that had been scheduled for 4 hours. We were into our 6th hour. We hadn't had lunch. And that person obviously needed nourishment. You just can't carry on without some form of nourishment. Now back to the question that Brian Gover posed. The amount of time that people estimate it'll take for a settlement conference, for a mediation, is often underestimated. And sometimes when it looks like it should take 6 hours, the parties say, oh, it's not so difficult, we can do it in 4 hours, and you find out that at 5 hours you might be starting to smell a settlement. And sure enough, it goes 6 hours. So I would caution the center not to be overly ambitious with what they're trying to accomplish. And I'm pleased to see that now they have, in fact, reduced the number of cases that they think they'll be able to hear, so that there's a better opportunity, I think, for a success rate. The types of cases that are going to the center are different from the types of cases that I often encounter, in that I often deal with personal injury motor vehicle cases in private mediation. And there it's really important that the parties be able to have the time to express what they want to express, and things aren't quite so neat and simple as they might be in terms of emotions, except where you maybe got to have a shareholders dispute with respect to commercial cases. The amount of the time that a session will take depends on the parties, depends on their counsel, depends on the third party neutral, and the effectiveness of the pre-ADR session process, like the meet and confer. If that has been an effective utilization of time, then I'm confident that a mediation session can be held in perhaps 2 hours. But the pre-mediation meet and confer has got to have taken place, and it's got to have been a meaningful meeting. Just with respect to that, at the center, Don Short gave you a bit of a view. There are breakout rooms, there are hearing rooms, and I understand that there will be a light refreshment center, which will please Justice Blair.
No, I'm going to take the floor from you all. Brian, I suspect you've got more on your list, but I think what we should do, we promise people an opportunity for questions. So what I'm going to do, I think, is give you folks the hook and invite the members of the task force, the steering committee, to come up to deal with questions, and then if we've got some time, we'll pick up the little bit that's left. But thanks you to the four of you. And, Can I remind you to fill in your questionnaire and also any suggestions on the program? I have one question from the floor, which was, if your case does not come up for ADR, in the sense it is not picked by the random selection, can one party compel the other party to show up for ADR? You're on.
No.
I think we're agreed on no. The best you can hope for is to convince the other side to come, or ultimately have an order from a judicial officer directing you to the ADR process, but until you get such an order, you can't get there. Is that fair?
That's fair. I would also suggest to you that there are those people who think that the better tactic is to try to crush the other side by motion after motion after motion after motion, and just sort of do a war of attrition. And that party would think that it's not in their interest to go to an ADR session. I turn that around and say to you that that's a very valuable thing. I would think that that party who wants to get involved in the war of attrition should come to an ADR session. They will use up some more time, some more money. On the other hand, if they go there, they just might find that there is a solution to the dispute that's mutually beneficial. So try that one on for size with the party that doesn't want to go to an ADR session.
Question here?
Thanks. I have two, actually. First is, what's the expected lead time between the court issuing a Form 1 and the scheduling of the meeting at the ADR Center?
Because there's a tape and everything else, the question is how much lead time from the Form 1 to when you're going to get to the center. Brian?
We anticipate that there will be about 6 weeks lead time between the issuance of the Form 1. And it was the committee's view that that would give council enough time to, first of all, ensure that the date complies with their schedule and to advise the center of any difficulty in that respect, and secondly, to comply with the meet and confer requirement.
The second question was directed more sort of a comment that Nancy made, which is the issue of cost that might arise out of ADR. It would seem to me if there's a rule that discussions in the context of ADR are completely privileged and confidential, how can you refer to those discussions when you never be in a position to ask for costs?
If I can address that, Don, the comment I was making is from the point of view of a practitioner looking at the practice direction that we've drafted, and it's more in for the session where the rules, you have to come at least to one session, even if you're not willing. And so it's for the party who comes, let's say, doesn't prepare for it, doesn't, it is really not interested in settlement at all. I think ultimately at a trial, that could be some evidence. Obviously, you wouldn't be able to use any evidence of the discussions, but the lack of willingness and cooperation at the time, I think, could be used as evidence of if you're building a case for solicitor-client costs, as it were. And there are some recent cases coming out where costs have been awarded on a higher scale, where there's been a lack of willingness to settle cases that should have been settled. So that is the only scope I can see as a practitioner looking at the practice direction for using costs if you are in a position where you're trying to get someone else to come to the table. And it might just be one aspect of the case that you're using, you know, if you've got offers to settle and anything else that you can use.
Next. Here you go.
Given that some cases will be more ripe for ADR after discovery and some before, will there be any determination made by the center as to whether, by looking at the statement of claim, the pleadings, for example, as to whether a Form 1 is sent out to a particular case? What I have in mind is a case where you send the form, counsel look at it, and they say, well, gee, this case might be a case where ADR may help, but we won't know until after we have discovery and flush out some of the factors.
Well, let's look at it from a very realistic point of view. Counsel are very dedicated it to providing a statement of claim. In theory, the statement of claim should be quite explicit. Then counsel are very helpful with respect to preparing a statement of defense. That should be also very helpful. It should not be a situation where the parties are strangers. I mean, they know each other. They've had some connection with each other. So I would assume that by that particular stage, the parties have a pretty good idea of what the nature of the dispute is between themselves. And I think it's a fair observation that business people are quite willing and able to make very significant business decisions without the benefit of having exhaustive discoveries and production. So much so that in fact sometimes you wonder what the dispute is because it's buried underneath all of the paper. And it's not really until you get to the 14th day of discovery that somebody finds something that they think they can twist into a good case. So all I'm saying to you is that I think if you adopt a business person's point of view, you'll find that you can take a good look at the nature of the dispute between the parties and see whether or not it's ripe for settlement.
Here. Yes, the Form 2 requires you to at least list them, and frankly, I would expect that the meet and confer would be an opportunity where you'd show me yours, I'll show you mine. Yeah.
But that's not the same as a full affidavit of production, though. Affidavit of document.
Is there any flexibility in the rule that you must turn out at the session with the authority to settle with your client, your corporate client, representative of the corporate client, versus the authority to settle? The reason I ask that question is any flexibility in that many large national corporations have a hierarchy of authority for the expenditure of funds, and you reach a threshold where you require the approval of the executive committee or indeed the board in some situations. And it seems to me that many cases might be prime prospects for ADR, court-connected ADR, because of this rule, that couldn't be considered.
Justice Blair?
I think probably that you raise a good point, and that's the sort of thing that will be worked out in the first ADR session with the DRO or with the judge. Just as I think that there will be some cases, to adopt Paul Iacono's analogy, where the cake has to bake a little while longer as well. But those are the sorts of things that good counsel and good DROs and judges can work out in the ADR session, and they can plot the course of the alternative dispute techniques that are to be used on the case, if they are to be used on the case in that way.
I just would add, though, that I really wouldn't expect counsel to show up at an ADR session saying that Megapolis Oil Company is not able to have somebody there with the full authority to settle when the meet and confer aspect of it shows that the amount in issue is $1,000. No, but some counsel might.
Not me.
No.
I was going to ask further. I suppose you would iron that out at the first session and say, look, my position with respect to my client is this. The plaintiff is looking for X thousand, hundreds of thousands of dollars. I agree the issues are not all that difficult. This is a case that can be resolved. But expenditure of some money is hard for approval. So I suppose at that point, you would say, well,
That's right. In a sense, the other side's going to turn their mind to whether or not they want to go ahead. But if it's a reasonable, you may well say we're going to make as much progress as we can and come back. And frankly, I think a lot of that should happen before you get to the first session. If you know you're going to have a problem with consents, then maybe you've got to wait till that person's available. At the back.
Just as far as the corporation I represent, haven't been sued for less than $1 million, which haven't even left the garden.
Try again.
Yes, very
you've got a scheduled session. They're going to be served with it, so that the recalcitrant party is going to know that the session is to happen. So long as the session has happened, even if they didn't show up, you're now in a position to sign Form 4 on your own. Because remember, you can sign it on your own once a session has happened. It's just you can't all sign it and skip a session.
Well, actually, you can.
All right.
You can all sign it and skip.
You can, but if that defendant's willing to do it, but if that defendant doesn't want to play ball at all and isn't signing anything because they don't know what it means, then you're stuck with having to go through that hoop.
Come in and have a cup of tea.
At the refreshment center.
Back?
From a practical point of view, whose call do we answer? The ADR appointment that we have, or the court's trial coordinator says you're on tomorrow?
You're on tomorrow.
You're going to get the ADR call much earlier.
No, I know, but you also have a scheduled date which you could be called to court in terms of,
Oh, I see. Another case.
somebody's time, or somebody's going to lose the 2,000 for the judge at the ADR.
We know that the council will do their best to make it all work. Last question.
There were some comments about these mediation sessions taking out of financial development. I was wondering whether there's any mechanism or any consideration given to a mechanism for a 48-hour cooling-off period. For the instance where council declines to agree on the dynamics, but the next morning they wake up and say, well, maybe this wasn't so smart. Can they back out or thought about it at all?
No.
Better keep your cool head when you come to your agreement.
Ladies and gentlemen, this afternoon marks the beginning of a new era in litigation in Ontario. There will undoubtedly be growing pains and bumps along the way, but I have no doubt that this initiative will facilitate better access to justice for the citizens of Ontario. And I think it's clearly in keeping with the traditions of the bar. I thank all the speakers for their assistance today. I thank you for coming. I ask you to spread the word because you know that nobody but the people in this room know anything about this. So would you make sure that your friends hear about it? There are videotapes available, there are audio tapes available, and the members of this committee are willing to come to your firm and tell you and your colleagues about it. It's an important development. Thank you for coming, and good afternoon.
Dress rehearsal.